Hello. So we're going to talk about racial segregation, school segregation in this presentation. And we're going to cover quite a bit of history here. You'll note that this particular presentation and the one coming after this dealing with church and state, we get away from students and student rights and do more of a broad look at schools and school districts and the law, and then we'll move into teacher rights. But for this presentation, we're going to look at racial segregation and how this has gone on in American history, and then ask the critical question, where are we today on this, and how have we made it to where we are today? So let's take a look at the timeline of events, and I'm going to refer back to this timeline periodically as we go, especially toward the end here. So we're going to start by looking at how schools were set up in the 19th and 20th centuries. And obviously the big thing we're building up to is the Brown decision in 1954. Before the Brown decision, there were attempts to desegregate public universities, and then we'll mention briefly how we moved to Brown and get that decision in 1954. And you can see that I have labeled the Brown decision from 54 to 68. And we're going to talk about that time period in the 60s and what was happening with school desegregation. And then we're going to switch in the late 60s and start referring it to school integration as opposed to segregation. And integration is really going to take on two different time periods, from 68 to 72, and then since 72, basically the last 40 plus years, and where we're going with integration now. So let's start out in the early part. Everybody's familiar with the way schools used to run, and a clear example of this came in 1849 in the case of Roberts versus City of Boston. This was a district decision from the federal courts, and you can see that in this case what happened was the courts ruled that separate schools were legal. And it's important to see the date here, 1849. We're starting to move toward common public education in the mid-1800s. And so it's not a surprise that we see a case come out that allows for the separation of public schools based on race. Now, what was not around in 1849, of course, was the 14th Amendment. So let's look at the 14th Amendment. The 14th Amendment is a real important amendment. As we have talked about throughout the class, the 14th Amendment is the one that incorporates the Bill of Rights down to the state level. Keep in mind the Bill of Rights initially applied to the federal government and did not apply to states, but through the 14th Amendment that talks about equal protection and due process, those have been brought to the state level in a process called incorporation. And by now, all of the Bill of Rights have been incorporated to the state level. The last one, as I've mentioned before, being the Second Amendment, which was only incorporated in 2010 at the state level. Nonetheless, what the 14th Amendment did was, the most important thing here is it defined a citizen. And you need to understand the context in which the 14th Amendment was approved. This was 1868. The Civil War lasted from 1861 to 1865. As a result of the Civil War, there were three amendments passed, the 13th, 14th, and 15th. The 13th Amendment abolished slavery, so that's an easy one to be done with. In the sense of it's easy to understand, not that it's an easy amendment to be done with, but it's an easy one to understand. After that passed, though, what happened to those freed slaves really started coming into question, and so it's no surprise that quickly behind it, simultaneously, were the 14th Amendment was being worked on, and the 14th Amendment defined a citizen. And so when the 14th Amendment was ratified, all of those free slaves suddenly became American citizens. Whether they were or not is not in question. Now they are American citizens. Further, the 14th Amendment states that no state shall deny any person within its jurisdiction the equal protection of the laws. And so as a result, this begs the question if separate but equal schools violated the equal protection clause of this amendment. And that is going to go back and forth over time. And as it starts working up, it will get to the point where we finally get the seminal case in the 19th century dealing with racial segregation. And of course, that's the Plessy versus Ferguson case of 1896. And in this case, Plessy was an octoon, meaning that he was 1/8 African American. This was a test case. They specifically tagged him to sit on a train in a car that was not designated for African Americans. And they took it to, he was arrested. They ended up taking it to court, of course, and the final result was the court came down and said separate facilities, as long as they're equal, are constitutional. And so I want to bring in kind of an outside point here that while we revere in general what the court is and what the court stands for, it doesn't mean that the court does not make errors. And I think that we today look back and see this as an egregious error on the part of the court that they allowed this to happen. But it was a sign of the times, and while it was law, it was the law of the land. Thank goodness, though, that faith in our institutions allows us to see the errors as we go and change them. And so that's obviously what will ultimately happen, is this will be changed. Now, the next error in here really comes after World War II. So there's a lot happening from 1896 up to 1945, the end of World War II. Specifically, you see a lot going on in the early part of the progressive movement, the early 1900s. You see people like W.B. Du Bois and Booker T. Washington and Marcus Garvey, and these people come out and start working for the rights of African Americans. Unfortunately, World War I comes into play, and World War I really puts an end to the progressive movement as we saw it happening in the United States. And so we didn't get to see the endeavors of these leaders come to fruition. We entered into the 1920s, a time of isolationism, and it really was a time when America kind of stopped looking at others and looked in on itself. And of course, this is the Roaring '20s and all that goes along with that. And the rights of minorities, such as African Americans, kind of fell to the wayside a little bit. You do, of course, have the Harlem Renaissance, which, of course, is going to bring a lot of attention to African Americans in that realm. But it's kind of just going to be latent in the background. And it's not until we get into the Depression, and then as a result of the Depression, or in addition to the Depression, I should say, not as a result of, we're going to lead into and get involved into World War II. At the end of World War II, and there were African Americans, of course, serving in the military throughout the war. At the end of the war, a lot of these African Americans are going to come back home. They will have seen or would have seen the oppression that they were fighting in Europe and Asia. They're going to come home and they're going to face what feels like similar oppression. in the United States. And we're going to see a revival of the movement that stalled or kind of slowed prior to World War One in the early 1910s. And so through people like Thurgood Marshall, who will ultimately become a Supreme Court justice himself, the first African American to serve on the Supreme Court, post-World War II is going to start seeing a fight to end this school segregation that was codified with Plessy versus Ferguson. Now, Marshall and the others want to start with higher ed. They feel that working through higher ed will be the path to go. There's not a perfect case in Common Ed, even though they're out searching for this perfect case. But they're going to work in higher ed. And the first couple of cases actually deal with Oklahoma. So Ada Lois Scipio Fisher, 1948, wanted to go to law school at OU. And OU created, as a result of this, a law school in the top of the Capitol building, in the attic of the Capitol building, and told Ms. Fisher this is where the black law school is. And so that's, of course, going to get wrapped up in the courts. Shortly after that, George McLaurin wanted to go back and work on a graduate degree at OU, and they fought and fought. This picture here represents a typical class that McLaurin may have seen, where he was segregated in the school so that the white students could not see him, but he saw the professor. I had an OU professor once tell me that during lunchtime, the cafeteria would close for the first 15 minutes, and Mr. McLaurin would go in and have his lunch, and then after he finished, it would open and all the white students would go in. So this was inherently unequal and will also get caught up in litigation. Another case, Sweat versus Painter, 1950, involving law school entrance in Texas. And so all these things are going immediately after World War II. Like I said, the goal was to desegregate higher ed institutions and then move to Common Ed. But the perfect case arose before the higher ed institutions were finalized. And the perfect case, of course, was Brown versus the Board of Education of Topeka, Kansas. Brown was a young black girl who had a white school close in her neighborhood, but because she was black, she had to walk through a train yard to get to the black school, and it was further away, and it was less safe for her. And the key here is that the Brown case was outside of the South. That was one of the keys that Thurgood Marshall wanted to have in a test case, was to get a test case that was out of the South. And so by doing that and bringing in Brown, they thought this was the perfect case. So just a little background on what was happening in 1954. Of course, Dwight Eisenhower became president in 1953. Earl Vinson, I believe it was Vinson, who was Chief Justice of the Supreme Court when the Brown decision gets there. And Vinson suddenly passes away. And so Warren has to find a new Chief Justice. And he taps Earl Warren, who was then, I believe, the governor of California, and nominates him to be the Chief Justice of the Supreme Court. And so Earl Warren comes in and is put on the court and states that he needs to redo everything as far as the Brown decision, because it's such an important decision. And it was a fast decision as well, because he wanted to get all the justices on board, but he wanted to get it out because he knew it was important to the country. And so the decision comes out, I believe about 3 months, I'm not positive about that, about 3 months after the decision was made, they report out. And of course the decision, the famous part of the decision was that the justices stated, quote unquote, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. And so now it sets in motion that schools have to desegregate. But what does this mean? This does not give a roadmap of how this is to happen. And so what most people don't realize is there was actually a second Brown decision a year later. And in this decision, the court came down and said, you must desegregate your schools, quote unquote, with all deliberate speed. But again, what does all deliberate speed mean? And there have been books written about this, and Gary Orfield is one of the people I will highlight in the end that talks about this. Excuse me. So, as a result of the 55 decision that said with all deliberate speed, the reactions around the country were mixed. The worst reactions came in the South. Schools closed, literally schools closed. There were whole counties in Virginia that closed school for the whole year, 1955-56 school year. Said we will not desegregate our schools, so we're just going to close. They paid white students state money in the form of vouchers to go to private schools. We've never heard that before, have we? Anyway. In Little Rock, the governor, the Little Rock Nine, Governor Orville Falbus at Central High School in Little Rock, Arkansas, there were 9 students who were chosen to go to Central High School, and they were taunted and spit upon and hit and things thrown on them. And the governor refused to act, and so President Eisenhower authorized the National Guard to come in and take over. And those 9 students went on to go into Little Rock High School. I'm not sure how many of the Little Rock 9 wrote stories of their experiences. Melba Patello Bills was one that I read, and I remember because it was really a very good accounting of the story, her story, in the sense that you really felt what these students were going through. This particular video, I'm not going to click on it. This particular video here takes you to an Oprah episode when she had the Little Rock Nine on back in the 90s. And you can watch that. It's probably not the best. There are documentaries on YouTube. You can just Google or go to YouTube and search the Little Rock Nine and look for the PBS documentaries. Those are probably much better. This is probably more of an emotional tug. But it's good nonetheless. So it's about 10 minutes. The main point here is that the federal government really had little resources or recourse in how they're going to deal with schools, school districts who resist what the court said. And in fact, the courts came back, and in the Briggs decision, 1955, the same year as Brown 2, it stated that basically what had happened was that the courts said that segregation was illegal, but that in doing so, the courts did not require integration of schools. And so this is how schools got around this. Okay, I mean, remember what we said early on in this course. You see seminal cases that define a topic, and then those are what I would call the trunk of the tree, and then from that trunk grow all these other cases that interpret what that first case meant in small pieces here and there. So the Brown decision said that separate is inherently unequal or inequal, the Briggs decision says, well, yeah, it says that segregation is illegal, but the decision didn't require us to integrate. Okay, and so this is why I said the federal government really does not have a lot of recourse in how to deal with this. There will be cases brought and taken through to the courts. For example, the case of Griffin versus County School Board of Prince Edward County. Earlier I said that one of the ways that schools got around desegregating was that they simply closed all schools and they were giving vouchers to white students. Well, in the case of Griffin versus County School Board of Prince Edward County, that's in Virginia, the Supreme Court ruled that contributing tax funds for students to attend segregated private schools was a violation of the Equal Protection Clause of the 14th Amendment. And so again, Earl Warren is still Chief Justice here during this court. And consequently, as a side note, 1961, Dwight Eisenhower stepped down for the presidency. He served 2 full terms. When looking back at his presidency, and somewhere I read this in a biography or something of Eisenhower, when asked about his worst decision he made as president, he said his worst decision was appointing Earl Warren to the Supreme Court. Now, I don't remember if that meant because of the Brown decision that came immediately after, probably one of his most important. But Warren had a lot of important decisions going through the 60s. A lot of the things that we talk about today, like Miranda and things like that, that protect citizens, came from the Warren Court of the 60s. It was viewed as a very liberal court, looking back on it from today. So I'm not sure if he meant that or if he meant the Brown decision, but he did say the worst decision he made as president was appointing Earl Warren. Nonetheless, in 64, we see basically how the government deals with schools who are unwilling to desegregate by taking them through the court system and slowly dismantling these tactics that are being used to avoid desegregating schools. So there really is not a lot of desegregation happening since 1954 and 1955. It really doesn't start happening until after 1965. And what we see in 1965 is the Civil Rights Act of 1965. And I should have added in here also that in 1965, Lyndon Johnson signed the Elementary and Secondary Education Act, which started, formalized some of the things that Eisenhower had done as far as education, but it put it all into a law. And this is where we get our title monies, specifically Title I, from, but all our title monies. Title I is the biggest of the title monies. And this comes, in 1965, Lyndon Johnson sent out $13 billion from the federal government to start the Elementary and Secondary Education Act. Today, we know it as Every Student Succeeds Act. It was formerly the No Child Left Behind Act. And the second largest single payment of money from the federal government into education came in 2009, actually, under President Obama, when he sent out the ERA money, and he distributed $11 billion. Not quite the equivalent, as close to the $13 billion of 1965, but nonetheless, it was the second single distribution of federal money to public education in the country. So the Civil Rights Act, though, was important because now the federal government has legal authority to go in and investigate schools and how schools could, what schools were doing, and if a district or a state were doing something that went against the way the rulings were being interpreted, now the federal government had a right, or had a legal right, a legal standing to go in and say, we're going to withhold money, or something more than that. Mainly it was withholding money. So as a result of this, what we see are a lot of freedom of choice plans. Freedom of choice meaning districts would open schools and say, hey, you know, all the black students can go where they want, and all the white students can go where they want. And what we saw was uh, that typically races did not mix. And so even with the freedom of choice plans, which became popular in the 60s, the races were still not mixing and schools were still segregated. And so we see another case go to the court. And this is, if you remember that timeline, I told you to refer back to that timeline. I said that the Brown decision is there's a time frame from about 1954 to 1968. In this time, we see very little action. We see freedom of choice plans coming into play, but not really being utilized very much. 1968, we see a new time era come in from 68 to 72. And what happened in 68 was the Green case. So the case Green versus County School Board of New Kent County, again out of Virginia. This was a watershed case. The court finally said, hey, we're tired of delays, all these things that you're doing to avoid school integration, and also importantly, the phrase desegregation of public schools started changing over to integration of public schools during this period as well. And out of the Green case came what they call the Green factors. These are 6 areas in which the courts and specifically the Office of Civil Rights within the federal government, now a part of the federal government as a result of the Civil Rights Act, the Office of Civil Rights would investigate and ensure that these factors were met. So that basically in all of these areas where students were concerned, the student populations had to represent the populations of the students in the district as a whole. So when we're talking about student assignment, let's say we have an urban school that has 50,000 students in it, so there's probably 4 or 5 high schools. In the 1960s, one of those high schools would have been designated as the black school. The same with a couple of middle schools and a half a dozen elementary schools. The Green factor said that starting in this period, your student assignments at the schools had to equal roughly the student population within the district. So no longer could you have schools with 99% white and the other high schools 99%, or I'm sorry, one high school 99% black and the other 4 high schools 99% white. If a third of your population were African American and 2/3 white, then all your schools had to represent that. So schools had to redraw attendance zones and in order to get this student assignment ratio balance. Faculty also had to be representative of your population. In other words, if you had black teachers, and schools did, then those black teachers could not be concentrated in one school and all the other schools have white teachers. The same with staff. Transportation had to be provided where necessary. Extracurricular activities had to be integrated and had to have equal access, meaning that all schools, if they were going to offer an extracurricular activity, had to offer something similar at all schools. And then finally, facilities. All the schools had to be brought up to equal facilities. So a big thing then coming out of the Green case. So this is why we say 1968 started a new era in school desegregation or school integration. One last thing here under this time period is the case of Alexander versus Holmes County Board of Education, and this brings in the term unitary schools or unitary status. And if a school is considered, or district, I say school here, I mean districts. If a district is considered to be operating a dual system, that means they have not met all those Green factors. And they're going to be under oversight of the federal government and in danger of losing federal funding. So in order to continue to receive federal funding, they must start making plans. This is 1969. They must start making plans to move toward what we call a unitary school or unitary status, meaning they have eliminated the vestiges of segregation within the district. They have met the green factors. And so that unitary status is still in use today. Dual system and unitary system are still in use today, and there are still schools being investigated by the Office of Civil Rights. I've been in districts that are under OCR investigation for operating dual systems. So we're not there, and we'll talk a little bit about why we still see these the reasons for these existence of these systems today, or the organizations to monitor these systems. So a couple of important terms here that we need to understand are de jure and de facto, because this is really going to start coming into play here. De jure and de facto mean if something is done by law or if something is done as a result other than law. When we're talking about school segregation, de jure segregation means that there was law in place and that the schools were segregated based upon law. De facto segregation means that there was no law in place, that it was something other than that, such as housing patterns that created neighborhoods that were separated by races. And as a result of that, the school systems, neighborhood schools, are separated by races, and they don't follow the green factors consequently because of this. And so this is not done by law, but it's simply done because this is what the people in the city have chosen to do. Whether they were complete free will is another video. Okay, but nonetheless, these two terms are very important. And in 1963, going back before the Civil Rights Act, the Green case, the Seventh Circuit Court in Illinois, I believe, Gary, Indiana, but I believe the Seventh Circuit is out of Illinois. This is an appellate decision. Stated that de facto segregation is constitutional. Okay, it's that the Brown decision, and subsequently, even if it's after this, the Green decision, are dealing with de jure segregation, okay, namely in the South. And so as a result of that, we're going to see some cases come up in the early 70s that start getting outside of the South, okay. So it's just a couple of important terms to remember, de jure and de facto. And the reason they're in italics is because they're Latin words, which according to good APA, we put foreign words in italics, okay. So back to where we were. 1968, Green case. 1969, the Holmes case. We understand what the term dual system and unitary system mean. The next big case is going to come in 1971, and this deals with Charlotte, Mecklenburg, North Carolina, again in the South. The Swan case, Swan versus Charlotte, Mecklenburg Board of Education, is looking at these green factors and brings into some definitions. It's kind of defining a little bit more of the Green case. So, number one, using racial quotas. The justice has stated every school in the community does not have to always reflect the racial composition of the school system as a whole. The elimination of one-race schools. One-race schools are permitted only if close scrutiny showed the assignment of pupils was not a part of a state-enforced segregation. The district must show assignments are genuinely non-discriminatory. So you can see it kind of start to chip away at Green. So Racial quotas are starting to pull back on a little bit. The idea of a one-race school, uh, there are loopholes in there now as a result of Swan case. A couple of other things came out here. Racial gerrymandering of attendance zone is permitted if de jure segregation has prevailed. Will this be considered? So, in other words, if legal segregation has prevailed in the past, then racial gerrymandering of attendance zones will be considered, not accepted, but it will be considered. What we mean there is gerrymandering in the sense of gerrymandering that we usually talk about with politicians. Here we're talking about attendance zones, carving out attendance zones to fit in unnatural attendance zones. And I don't know the background of the Swan case, but I'm sure people were pulled away from what would normally have been their local schools to go to other schools as a part of trying to meet those student assignment quotas from Green. And then finally, the use of busing. Directly addressed with Swan, the court allowed busing. It said desegregation plans cannot be limited to walk-in schools. So busing is going to be an important issue, and we're going to see Oklahoma City get involved at this point. And the Oklahoma City case that's going to start in the 70s will not be finalized until the early 90s, as we'll see in a slide in just a minute. So that's kind of what's happening. Schools are starting to integrate as a result of Green, but we see some changes coming in the early 70s. Remember that time frame was 68 to 72. There are some big changes coming in the early 70s, though, and are going to start putting the brakes on the integration that's happening after 68. And by the way, I should add, it is not in here, but I should add that it was during the early 70s, as a result of Green, that Tulsa Public started integrating its schools. And it was in 1973 that Booker T. Washington, the formerly all-black high school, was integrated and turned into the magnet school that it is today, 40 plus years later. That was directly a result of the federal government coming in and telling then Superintendent, I forgot his last name, Bruce Howell, Dr. Howell, then Superintendent Howell, you either integrate or you're going to be classified as operating a dual system. And so that was what had happened previously. The year before, the middle schools were integrated, and before that, the elementary schools. So Tulsa Public was going through and is a prime example of a school system that kind of slothed its way through, if that's a word, the process until the Green decision in 1968. But some important things are going to be happening in the country in the early 70s. The main thing that we see dealing with racial segregation is the makeup of the Supreme Court is going to change dramatically. And through the 1960s, we have President Kennedy, and then President Johnson, and in 1969, President Nixon is going to be sworn into office. President Nixon served until 1974 when he resigned from the presidency. The first, maybe not the last, to do that. But during his short term, relatively, considering he was elected twice, but during his time in office, President Nixon actually appointed 4 Supreme Court justices to the bench. And in looking at this in my studies, I compared conservative appointments to liberal appointments. Okay, now we're taking if you disregard the idea that the appointment, that the reason we have appointments of justices and not elections is to take away the political side. But nonetheless, in looking at conservative versus liberal appointments, the conservative appointments outnumbered liberal appointments up until I think it was 1973 or 72. It was one of President Nixon's appointments. And ever since then, conservative appointments have outnumbered liberal appointments on the bench, period. Ever since then. I think it's 1973. So, and this is a side, this is free information, so you don't have to listen to the next minute if you don't want to, okay? So, we hear a lot of controversy over recent appointees, Merrick Garland, and now Gorsuch. And the idea that the court has to be saved, but in reality, the court has been ruled by conservative appointees ever since the 1970s. So a lot of those wailings are either intentionally leaving out that fact or simply a sign of ignorance. And I'm not sure which is which, even when we listen to the people speaking. So anyway, that's all the free information. We're back on target now. So with the change in cases, or the change in leadership of the Supreme Court to a conservative appointed court, we see the court hearing less and less cases. But the ones the court does hear are important. Okay. So in 1973, we get a case out of Denver, Colorado. And the reason it's important is because it's out of the South. Keys versus School District Number 1, Denver, Colorado. And this harkens back to the 63 decision from Gary, Indiana, that said de facto segregation is constitutional. So this case is trying to fight that de facto segregation. Keep in mind, de jure segregation was really specifically tied to the 17 states of the South. So in this case, the Supreme Court said the plaintiffs must show intent to segregate if segregation were in fact de facto segregation. And so this gets into a whole other area of housing and things that are a different video. But what it's doing is it's starting to pull back on the government's oversight into cases, because de facto really rules outside of the South. And so unless there can be an intentional movement on a part of the district in these areas outside the South concerning de facto segregation, then the court is not going to step in and rule in a school's favor or a plaintiff's favor. Okay, so you can see the court is not only going to hear less cases, but their emphasis is going to start being less. They're pulling away from decisions impacting positive change for schools as far as integration goes. The second important case here comes in 1974, and this involves Detroit, Milliken versus Bradley. Detroit wanted to integrate by using surrounding districts, and the courts ruled this to be unconstitutional. And in 1977, the courts heard a second Milliken case. So keep in mind, so what that first part said in Milliken 1 is that using the surrounding districts in any form, whether it's through busing or sharing of resources or whatever, is unconstitutional. Can't do that. You can't have other districts help you. You can't force them to help you. The Milliken 2 case in 77, the justices stated there are three factors to consider with remedial practices facing districts who are considered dual systems, dual districts. So number one, the remedy should be commensurate with the nature and scope of the constitutional violation. Number two, the court's degree should be remedial in nature to restore as nearly as possible the victims of discriminatory conduct to the position they would have occupied in the absence of such conduct. And number three, the courts must take into account the interests of state and local authorities in managing their own affairs consistent with the Constitution. You can see, especially in that third bullet there, the third item, where the court is pushing this back on local ideas and local thoughts. And again, it's out of the scope of what we're talking about here, but I think there are issues where the court has to take the role, the active role, and not let local ideas reign. But that's neither here nor there. This decision, Milliken 2, pushed the conversation away from student reassignment and more to the educational program remedies such as reduction in class size, summer school, full-day kindergarten, tutoring, magnet schools, and facilities. So we can see there are fewer cases coming through. What cases do come through, there are a couple here I don't have. There's a Kansas City case, I can't remember the name of the case off the top of my head, that wanted to use taxes to help supplement what Kansas City public schools are doing, and the court ruled against them, and they say they could not use tax base that have impacted other districts in order to obtain unitary status. There were some cases out of Texas as well. But you can see the court is, instead of offering cases to help schools integrate, they're starting to offer cases that give schools loopholes as to integration, in my opinion. So another important case that's going to come out of the 70s, and two important terms that we need to look at are affirmative action and narrow tailoring. Okay, so affirmative action, this applied formally to de jure states only, the 17 southern states where legal segregation had existed. The Regents of the University of California versus Bakke case, 1978, in a 5-4 decision stated that affirmative action violated Title VI of the Civil Rights Act where there was no previous de jure segregation. And so we see a blow to affirmative action. Affirmative action, the idea of racial quotas, in other words. So out of this come two important terms here, strict scrutiny and narrow tailoring. So strict scrutiny comes into play when there was no de jure segregation, no legal segregation in place, and a policy exists on racial classification for non-remedial purpose such as diversity. The court asked two questions. Does racial classification of the policy serve a compelling government interest? And is it narrowly tailored to achieve that goal? That's what strict scrutiny is. So let's see what narrow tailoring is. And this is an important thing here, narrow tailoring. Narrow tailoring says that while race and ethnicity can be considered as part of the diversity mosaic, they cannot be the raison d'etre, nor the criterion on which the movement of students among schools is based. The raison d'etre means the reason for being. Okay. So in other words, what's happened now is that race and ethnicity can be considered, but they cannot be the only reason that you assign students to schools. So what the court's saying is that you cannot assign students strictly on race in order to achieve a uniform system. Okay. The court will not permit racial balancing as a means to achieve diversity in school districts that have never had legal segregation or have been declared by the courts to be unitary. Diversity cannot be achieved by quotas for racial or ethnic classifications. So again, this goes back to the de facto schools here. The court will not permit racial balances as a means to achieve diversity in a school district that has never had legal segregation, the de facto schools, in other words. So again, now we're touting those schools. You cannot use racial quotas to gain unitary status alone. Okay, alone. Narrow tailoring must include a more holistic view than just race or ethnicity. Racial classifications must be part of a broader assessment of diversity and not simply an effort to achieve racial balance. Income is not a suspect class, as is race and ethnicity. Therefore, there is no constitutional prohibition on balancing student enrollments based on students categorized by percentages of farm kids. Farm kids is the term I use for free and reduced meals. These are your Title I kids. Okay, so in my opinion, what's happening here is that, and now I'm talking modern day. Modern day, I think that we still have racially imbalanced systems, and certainly racially imbalanced schools. I was in a school just not too long ago that was 99% black, and the district is not 99% black, but it's a school in the South, and so you can't use race as a single identifier to distribute students, make student assignments according to what we just read. What you can use, though, is socioeconomic status. And in my opinion, socioeconomic status not only covers race, it's more than that. It's a bigger, encompassing thing than just race. And that if you look toward working with low-income students and trying to balance your low-income students. And this is difficult, I realize, because you have low-income pockets in major metropolitan areas. But if you can work through low-income students, you're going to also cover race as well. Anyway, we'll get off that and move forward just a little bit more. Columbus Board of Education versus Pinnock. 1979, when a school system no longer discriminates between school children on the basis of race, it is classified as a unitary system. So I said that the time period went from Brown 54 to 68, and from 68 to 72 we saw a very short period where schools tried to integrate, and I use the term integrate, they were integrating, and of course in this period we saw Oklahoma City Public and Tulsa Public, the two largest districts in Oklahoma, do that. And then we see a change in the court. We see a change in the attitude toward what was happening in public schools in that regard, and cases going to the court started waning. It's not going to be until the late 80s and early 90s that we start seeing changes to this. And what's going to happen is we will see much more chipping away at the green factors. So I'm just going to go through these real quickly. Here we see the Oklahoma City case finally being litigated in front of the court. And what was happening in Oklahoma City, the court ruled if the district showed the current racial imbalance is not traceable to the original legal segregation, the district can achieve unitary status. Oklahoma City famously operated with finger plan and tried busing in order to integrate, and there were a lot of issues with that. Pitts versus Freeman, at the circuit court, it added quality of education to the green factors in 89, but by the time it made it to the Supreme Court in 92, the court chipped away and said not all 6 of the green factors had to be met, but as long as some were, the others could be left for further consideration. And then even as late as, or as recent as 2013, we see a case coming out of the Sixth Circuit Court of Appeals in Tennessee. It says, once a district has achieved unitary status, it is no longer under an affirmative duty to remedy imbalance that is caused by demographic factors. And that has allowed schools to resegregate. And that's the term you see now in literature, is the resegregation of schools. And that really started in the 90s, but it certainly is more true today. There's the Kansas City case, 1990. The others we just talked about. The Kansas City case using taxes to influence immigration. So how do we reach diversity then? So here are a couple of important things here. Justice O'Connor, who's no longer on the Supreme Court, in 2003 stated, the nation's future depends upon leaders trained through a wide exposure to the ideas and mores of students as diverse as this nation. However, she wrote, all factors that may contribute to student body diversity should be considered, not just race. And hopefully we're moving in that direction where we're considering more than just race. But unfortunately, you can't say that race is not a significant part of it. This is a case that came out in 2007 in Seattle. We saw the one from Tennessee. Here's one from Seattle. Parents involved in community schools versus Seattle School District. Schools can only use racial classifications as a compelling interest to remedy past de jure segregation, past legal segregation. And the government interest in diversity may be compelling, but cannot rely solely on race. So again, we're stepping away from it may appear, in my opinion, that we're stepping away from race and trying to encompass more things. And that's good in a way, but also you can't forget race. And I don't know what the answer to that is, but you can't forget it. Because again, like I said, I was in a school that had 99% black students, and the district in which the school is located was not 99% black. And this school was the lowest achieving high school in the district. And so those things are correlated. And we can't forget how that has happened. So that's a little bit about where we are with school segregation. We went a long ways. Unfortunately, personally, I feel we're kind of going back instead of moving forward. Some videos here that are good to look at. Gary Orfield is a big researcher in this field. He works out at UCLA. And there are some videos there where he talks about a lot of his work. Also, here are some desegregation, from desegregation to resegregation videos as well from YouTube that you can watch and get a better, much more detailed idea of what has happened since 1968 up to our current time. So enjoy.